Hello, my name is Joe Alter. In my previous video, I talked a little bit about standing, and as it relates to my case against Donald Trump for pardoning the January 6th insurrectionists. Uh, and I wanted to talk a little bit more about it because it's a giant hole in our system of justice. It all comes about from just the worst behavior we've seen in sitting presidents and originates in 1973 when the Office of Legal Counsel issued a, uh, a, uh, a memo on the amenability of a president to sit for an indictment while sitting as a president. And that 1973 memo, of course, found that the president's a busy guy. You can't waste his time with criminal indictments. He's got things to do. And the thing is yeah, sure, he's got things to do, but he's also got an entire department at his disposal in the Office of Legal Counsel to defend his interests and the interests of the presidency. And, not only now, he's also got the DOJ. So I find it a little hard to justify that the president is too busy to be indicted, particularly when they've so clearly conducted misconduct under the guise of legitimate presidential duties. The thing is, even the 1973 memo was pretty clear that they were only talking about lawsuits that were brought by, say, an ambulance chaser who's looking to make a quick buck off of the sitting president. Uh, you know, and it talked about monetary damages and criminal liability. Now, criminal liability, obviously, there has to be some way to hold a sitting president criminally liable for crimes. Uh, Even the 1973 memo doesn't imply that he can't be prosecuted. It says that the Supreme Court found post Clinton that the courts must be able to find a balance between their duties in the court and the duties of the presidency, and and that nobody's above the law, uh, and that prompted Randolph Moss, who's now a sitting judge in the D.C. District Court, to write a memo when he was working for the Office of Legal Counsel. And that memo re-examined, after the Supreme Court finding on Clinton, that memo re-examined the suitability of indicting a sitting president. And what that memo reviews, I'm going to link to it below, but what that memo reviews is there's a difference between conduct of the office and private conduct. And the memo makes a distinction, that there is a distinction between private conduct that the president does that's really not part of his duties at all, like Trump's insurrection on January 6th, or other things, but and certainly Clinton with his misconduct with Monica Lewinsky. That's not part of his duties as president. I'm not going to go into that, but the fair point that they're trying to raise is to make the distinction between public and private activity. And the problem is these memos are very self-serving. Office of Legal Counsel, we're all familiar with other Office of Legal Counsel memos, like the one on torture that was issued under Bush, that basically said, well, under certain circumstances, we have to not pull any punches, in the fight against terrorism. including our Geneva Convention obligations. But that's beside the point. The point is that the powerful, meaning office holders, people who sway public policy, people who fund office holders to sway public policy, have enormous influence on our courts. And it's all outside the Constitution. And this is how it happens. Office of Legal Counsel issues a memo and says, well, you really you can't waste the president's time with his misdeeds. So you could take that up with him after he's president. Yeah, he's got stuff to do. I mean, obviously, there's no justification for any of this. But what's happening behind the scenes is the Office of Legal Counsel issues a memo, and then the DOJ is bound by that memo, meaning the DOJ cannot go ahead and indict a sitting president because of that memo. Not because of anything it says in the Constitution, not because the Constitution says anything about it. It's simply a practical matter. And if you look at the memo, the way that they justify it is, well, they say, well, constitutionally, there has to be some way to bring an accusation of violation of constitutional amendments by a president, whether they're sitting or not. Because, of course, when he's violating those amendments, that's the time to do something about it, not after he's president. And the Office of Legal Counsel that was rewritten in 2000 says that it justifies the non-prosecution of a sitting president because there is already a perfectly available constitutional method for getting to the truth of what's happened, and that is a non-punitive lawsuit. For instance, like a lawsuit brought on under the Declaratory Judgment Act, for example, where you only seek a finding from the court. Did he do it? Was it illegal? Please tell me. And the court, Marbury versus Mass, and the court can't sidestep such an important constitutional issue if it's raised. The Constitution says that, and precedent says that. But nonetheless, the DOJ abides by this memo, which means that even if you have an honest prosecutor like Robert Mueller, the president's not going to get prosecuted for anything. And it begs the question, because the Office of Legal Counsel even says in its memo that Mueller could have brought a case for declaratory judgment, because the thing is the court needs to say when the president is guilty. The court needs to point out when the president has violated the Constitution. Because how is Congress supposed to vote on impeaching him? How are voters supposed to make their judgment about whether to vote for them again? How's the history supposed to look at what's happened and know what to say, whether he broke the law, whether the Constitution's been violated? I think those are pretty important, and you should, because this avoidance of process is a giant hole created in our Constitution. It's not created by the Constitution. It's created around the Constitution by self-serving presidents, judges, and allies of the powerful that can make a memo like that happen. I don't want to be disrespectful to Judge Moss, but he knows that it creates a hole because he addresses it in the memo, and he very clearly says that non-punitive cases can still go forward contemporaneously as the president is breaking the law, because that's when you want him to stop. So it's not my imagination here, but what has happened is things like this become traditions in the law, and those traditions are known as doctrines, where they say, well, you can't prosecute a sitting president, and it's nowhere in the Constitution. It's just become good faith. And the thing is that all that good faith depends on having a DOJ that's going to be free to evaluate whether the good faith response to conduct is to press an indictment, or press a declaratory judgment, so that the public can know what really happened. The DOJ has to operate, in order for any of that to work, the DOJ has to operate in good faith. And when you now have Trump v. United States saying, well, president can hire and fire whoever the hell he wants anywhere in the executive, particularly the DOJ. You have presidents that go through several attorneys general until they can get one to prosecute the people they want to prosecute, or to keep out the ones that want to prosecute him. This is not a good faith. This is not a good faith activity, and the Supreme Court has enabled it. Now, it's not necessary for me to fight the Supreme Court to just say, well, that's bullshit. And it's not necessary for me to say, well, that's bullshit, in order to bring a case. The thing is, I brought a case under the Declaratory Judgment Act. I don't ask for damages. I don't make issue of my harms, though I have harms. But it's created this hole in standing, where the only people that can bring a case against somebody that's powerful and well protected is because, let's say they've lost a leg, or some consequence that could never be undone, and they just want some compensation. Those kinds of suits can go forward, and here's why the courts that are very friendly to these, to the powerful and the connected, let those suits go forward. First of all, when you file a tort says, I've been terribly injured, I need to be compensated because I don't have a leg for the rest of my life. My wife left me, and the bills piled up, and I'm going bankrupt, and it was a horrible thing that was done to me, and it was completely a violation of my rights. But if you give me a couple $1 million, I'll settle this in whole. It's basically hush money. The court, by doing this, the courts enable an official form of hush money. And not only that, but the government pays for it because you're suing the office. So it's other people's money, personal conduct. I just think it's all wrong. It's total bullshit. But what upsets me is that even if you follow the rules and you file a non-punitive case that doesn't try to hold somebody criminally responsible, or try to press for money damages, or even raise a complicated claim that's not already proven out in court, the facts of the claim are so simple that the court merely has to say yes or no, that you could spend years arguing with the court whether you have standing. And the thing is unless you've lost a leg or something, you won't have standing, because that's the tradition they've developed. That's all built on these ideas of good faith. And the thing is, they say, well, wouldn't want to open the floodgates because then everybody would sue the president. I said, well, my response to that is everybody should sue the president until the merits of the case are heard and the constitutional question is answered. The courts have no right to sidestep in an individual case, and they can't keep sidestepping it because they don't want to answer the question. Letting any citizen file a case about the president's misconduct is just, and it's part of our Constitution and our First Amendment right of petition, for a citizen to stand up and say, this is bullshit. So, anyway, Clearly, I'm not going to be the one to persuade the court that they're wrong about standing. I've tried. I tried Alter v. U.S., taking the cases that I filed and saying, look, why do these cases keep getting bounced on standing? You have OLC memos that completely support the route to bringing a structural challenge. You have precedent that supports bringing structural challenge, not necessarily needs to have a personal hardship. The law is clear, but I'm nobody. I'm not even an attorney. I can't get the court's attention for more than a few minutes. I can get their attention just long enough to shut off the microphone. But why isn't the legal profession addressing this? Why isn't the ACLU defending our rights, our right to petition, to confront a wayward executive? Why isn't that something that the ACLU is interested in pursuing, even if all the case law is there, all the precedence is there, all the language of the Constitution is there? These organizations are companies, and their lifeblood is fundraising on cases, and those funds often come from interested parties. Like, for instance, the Anderson v. Trump was brought by Colorado Republicans that really didn't like Trump, and wanted to keep him off the ballot in 2024 because of everything that he did. I mean, it was a valid, just, righteous case, but the fact that they filed it in state court instead of the federal court is a fairly obvious flaw. Of course, that was going to be a problem, because you can't have 50 states deciding who goes on the ballot. But nonetheless, these are states' rights Republicans that want each state to be able to protest against the federal laws. So they filed it in a state court. There was a reason for that. And I guarantee you that's where their funding came from. Because they were even asked at oral argument, well, would you like, by the federal Supreme Court, well, what would you like us to do? Would you like us to re-examine the evidence, or take the state court's word for whether this happened or not? And the defendant, they were sued by Trump because they won in the state court. The defendant said, no, we don't want to examine the evidence here. What? You don't want to examine? You don't want to get to the merits of the case? You just want the federal courts to stamp it and say, oh, well, yeah, the state didn't do anything wrong. Let's get rid of the guy. I mean, obviously what they were going for was strengthening that state right. And if they happen to get him off the ballot, that's great too. But because they weren't a fan, or whoever was funding the case, not a fan. But, these organizations go into court with an agenda that is not always obvious to everybody. And there is nobody to represent our rights to petition the court, because it's not in their interests to defend it. They don't want maniacs like me going around filing cases against the president, because that's their job. That's how they raise money. That's their business. So, I don't know what to say. We live in a system that has self-imposed giant holes around its own constitution that prevents citizens from having a say in their governance. I even had a judge tell me, well, you can vote, you can petition Congress. That's not what Article 3 was created for, and that's not what the right of petition was. In the early days of the United States, we didn't even have such a thing as licensed lawyers. And we had many lawyers that were just citizens practicing constitutional law in the federal courts. Abraham Lincoln was such a lawyer. He had no Juris Doctorate, and yet he could, file federal challenges, challenging things like, the railroads who were trying to push the notion of corporate citizenship. This goes all the way back to the 1800s. And, it's been a struggle between the rich and the citizen and whose rights prevail. And it's really quite sad for me to see that the courts are willing to nibble around the edges and on a case that, regardless of what their comment is not going to affect the millions of other cases that need to be brought on behalf of everybody else that's been damaged. But they'll be happy to say in the context of a very narrow case, this is outrageous what the Department of Justice has done. They've lied to me in court. How dare they? All good things to have on the record. All brave of them. Some of them are even, Republicans. Brave of them to say, within the context of their party that's all but abandoned law. But it really does not get to solving problems in the broad sorts of ways that we need the courts to address our problems. Because we have, a runaway kleptocracy, and there's just no other way to say it. Everybody's got their hand in the bag. And my attempts have just been, I wanted to confront it. I said what I wanted to say, at least before they shut off the microphone. More people should say what they want to say, because that's what living in a free country actually is. If you've got a government that's breaking your constitutional rights, or even your neighbor's constitutional rights, or your friend's constitutional rights, you should be able to go into court and say bullshit. That is what the right of petition is. Anyway, that's all I have to say on the subject. It's clearly not going to be me that persuades the court. But again, the court has not gotten to the merits of any of my cases. Any of you could file a case as well and say what you want to say. Because until they reach the merits, the cases can't be closed. Cases cannot be disposed of en masse. Thank you.